Hello, and welcome to this lecture on interrogation, confession, and self-incrimination. So, today we are going to discuss interrogations. So, we've moved on from our unit about search and seizure, and now we are moving into looking at the person's rights during interrogation, namely the right to remain silent, Miranda rights, omissions of statements and confessions, and the dangers of improper or unlawful or inaccurate confessions. So let's begin by discussing the importance of interrogation. Now, understand that unlike what you see on TV, many cases are often only solved through a confession. Unlike what you see on TV, when we get to a crime scene, there's not always DNA or forensic evidence or eyewitnesses. A lot of times, conviction only occurs because somebody confesses. Without confession, a lot of times convictions would never occur. It's part of the reason that defense attorneys, their go-to advice for everyone, right, is don't talk to the police because it is virtually impossible to talk yourself out of trouble. If you talk to the police, you are almost guaranteed to talk yourself into trouble. And without a confession, many cases would never result in a conviction. It would often have to be dismissed before even going to trial. Now, with that understanding, please understand that if a case does end up going to trial, jurors place a really high significance on confessions. Even if all the evidence points towards a person being not guilty of a crime, if they confess and the admission comes in, even if there's DNA evidence that shows they are not guilty, jurors are still more likely to convict. Jurors place a really high weight on confessions. I mean, think about it. If somebody tells you to do something, it says that they did something, you believe them, right? Remember, the average juror tends to be not very highly educated or well versed in the law, or especially well versed in the intricacies of human psychology and interrogations. So what they hear, right, in their mindset going into a jury room is, well, if he didn't do it, he wouldn't have confessed, right? Because they think about themselves and they think, well, if I wasn't guilty of something, I wouldn't admit to it. But the reality is, and you might feel that way, but the reality is, people admit to things that they didn't do all the time. We'll talk later in this lecture about why people give false confessions, why they admit to things that they have never done. Now, there's a big jeopardy there because once people confess, it's really hard to get a jury to not convict this person because they've confessed. Now, that being said, even if there's a confession, defense attorneys will do all that they can to get the confession excluded from evidence. So, for instance, if the person was coerced or if Miranda was not read, defense attorneys will try their best to get that confession excluded. However, we run into a problem. You cannot unring a bell. So once that jury hears that you confessed, even if the judge says, well, it wasn't a lawful confession, you all can't consider it, what really happens? Juries consider it, right? Because why would you confess to something you didn't do? Again, it's no fault of the juries. They're average citizens. They don't have the training that you will have to understand why people make false confessions. Now, that being said, because of the sheer weight that jurors put onto confessions, they are often the subject of abuse. If we look at the Innocence Project and their records in terms of what causes a wrongful conviction, one of the leading causes, if not the leading cause, is false confessions. Right? So most of you know the Central Park Five, that case. It's a very famous case, and if you don't know it, I'd ask you to take some time and maybe do a little research into it about these, five young men who were accused of attacking and sexually assaulting a woman in Central Park. These young men, and some of them were, juveniles or pretty close to it at the time, confessed after lengthy, very coercive, high-pressure interrogations. After some of them spent significant time in prison, they were later exonerated through DNA evidence. So false confessions do happen, and they happen frequently because of the undue influence by law enforcement, who put such an emphasis on confessions because juries put such an emphasis on confessions. Now, there was a case that I worked on behalf of the Innocence Project when I was in law school. It was a case involving what's called the Franklin Field Eight. So it was these eight students or eight young juveniles who were had a neighborhood gang of sorts, but not really. They're more of just a group of friends. They were hanging out and they were drinking malt liquor in one of their rooms in this big project in outside of Boston. And at one point, they look across the street and they see two sex workers walking underneath a street lamp, and they decide to go and rob them. So the boys, they split up. They go downstairs. They split up. One group of boys approach from the front. One group of boys approach from the back. When the sex workers see them, one hands over her money. And they kind of push her around and they're very intimidating. And the other one runs. Now, when the other one runs, the boys chase her. They tackle her in the middle of Franklin Field, and at which point they all took turns proceeding to, allegedly, right, proceeding to rape her and then proceeded to stab her, ultimately ending up in like hundreds of stab wounds. And obviously, she dies. Now, the boys are eventually arrested and they start to confess, right? But one of them, who was really young, confesses, but under really odd circumstances, with a lot of coercion, a really long time being questioned, and it didn't seem like this young man did it, but just confessed to being a part of it, but then also taking place. Now, again, why is this confession? And if you believe it was false, in this instance, I actually didn't believe it was false. But if it was a false confession, right, why does it happen? Well, it happens because whether you're an adult or if you're a juvenile, so many cases turn on confessions that police put an overemphasis on them, right? Because a lot of times that's the only way to get a conviction. And because of that, they are rampant for abuse or undue pressures that cause people to confess falsely. Now, with that understanding, when it comes to interrogations and confessions, there are a number of constitutional protections designed to ensure that people do not confess against their will and do not wrongfully confess. Specifically, we see protections in the Fifth, Sixth, and 14th Amendment. The Fifth Amendment explicitly protects against self-incrimination, right? So we have an accusatorial system here, right, that is adversarial. So, because of this, people, when they are charged with a crime, have a protection against self-incrimination. They do not have to talk to police. They do not have to testify unless they choose to do so, right? There's nothing that will hurt them from not talking. However, compare that, right, to inquisitorial systems. For example, France. In France, France is an inquisitorial system in which the accused has no right of self-incrimination. And in fact, they are expected to talk to police and they're required to talk to the courts and have discussions with the judge and to testify. Our system does not require that, right, as a matter of personal liberty and as a matter of the way our system was designed. Now, the idea is to protect this person's autonomy and liberty interests, and to a certain extent, protect against self-incrimination. Because of this, one thing that our system emphasizes under the Fifth Amendment is reading of rights, to ensure that if you know you have rights and that you don't have to talk, that, right, you maybe are more or less likely to involuntarily confess or feel the effects of coercion, and then hopefully, knock on wood, also not falsely confess. The Sixth Amendment is also implicated, right? Namely, the right to counsel. We'll talk about that. The Sixth Amendment attaches during the first formal step to prosecute a suspect. Now, when we talk about this, understand that a part of this Fifth Amendment, and we'll get into Miranda, does talk about counsel. right? That not only do you have the right to remain silent and you don't have to testify, but that you also have the right to an attorney. And you can speak to an attorney before you answer police questions. And then obviously we also have the overarching 14th Amendment. The idea of the overall 14th Amendment is even if, let's say, Miranda has been read and a person understands it, if the police do something, even if they, follow the book, but they do something that causes a person to involuntarily confess, it is a de facto violation of the 14th Amendment. Instead, in order to be admissible and hopefully trustworthy, confessions must be made freely, voluntarily, and without compulsion or inducement, right? Without pressure or force, threats of violence, or without bribery, right? Compulsion or inducement. Any violations of these can result in a confession being excluded, and the hopefully, right, the case either being dismissed or brought again so a jury doesn't hear that a confession existed. Because remember, even if police violate it, and even if it gets suppressed at trial, if it gets brought up at all within the jury's ears, right, they will often convict. Because again, why would you confess to something you don't do? To help you kind of understand where things apply, and here's a chart to kind of help you understand what amendments apply and when during the prosecution. Now, obviously, we've already talked about the Fourth Amendment, the right to search and seizure. Now, normally that takes place, obviously, before the prosecution begins, right? Because the seizure, the arrest, begins the actual process of prosecution. With that being said, we talk about the Fifth Amendment. The Fifth Amendment due process clause, basically the right to a fair trial, applies at all stages of the process. Self-incrimination, however, within this Fifth Amendment only applies to custodial interrogations and all of the stages thereafter. The Sixth Amendment applies to all stages after formal charges are filed, and the 14th Amendment applies throughout. So let's begin by discussing self-incrimination and the Miranda. While I know you can read, here on the screen is the Fifth Amendment. The relevant part of the Fifth Amendment says that no person shall be held to answer for a capital or otherwise infamous crime unless, and then there's a series of protections. Going down to the big part for us today, nor shall be compelled in any criminal case to be a witness against himself. Now, obviously, this was written at a time that was very male-centric, so most of the pronouns in the Constitution, not all, are he, him based. However, obviously, this applies to anyone, regardless of gender or gender identity. So, in the Constitution, it very well and clearly states that a person shall not be compelled in any criminal case to be witnessed against himself. So, historically, this meant at trial. Right? At trial. But when we think about self-incrimination, it's actually a much longer and broader concept. So, when we think about self-incrimination, we begin with this idea that the Fifth Amendment only protects what's called testimonial evidence, right? Such as evidence that is communicative in nature. This does not protect things like the sound of your voice, right? So let's say that a witness says that on the night of the murder, they heard a man's voice say, "Stop right there." And so they get some suspects, they have them come in and say the words, "Stop right there," while this person listens so she can see whose voice it was. Well, that's not protected because you're not trying to communicate anything. She is just listening to the sound of your own voice. Similar to handwriting. It's not the words you're writing matter, it's the style of your handwriting that matters. When police talk to you, it's not what you're saying if they're thinking you're arrested or you're suspect for a DUI. It's the fact that your speech is slurred, right? So that is not testimonial. Similarly, showing your ID is not testimonial. What the Fifth Amendment protects is you making communicative statements. Right? We're not judging your quality of your voice and your handwriting or if your speech is slurred. Instead, we want to understand your message and the words that you're communicating. Now, that being said, testimonial evidence is not always protected. Right? Testimonial evidence is only protected, assuming there's an invocation of rights, if one, there is a substantial and real threat that the information may lead to criminal charges or establish a link in a chain of evidence. right? So the idea is just because you've been read your Miranda doesn't mean that it protects everything that you say. For instance, if they're questioning you about a murder and you say, I choose to remain silent, right? And then they say, well, do you want something to drink? And you say, yeah, like a Dr. Pepper. You can't say, well, hey, they made me talk after they told me my right to remain silent. They made me talk by asking me for a Dr. Pepper. Problem here is there's no substantial and real threat that asking for a Dr. Pepper is going to lead to information about criminal charges or establish a link in a chain of evidence. So not only does the testimonial evidence have to have a substantial and real threat, the evidence then also has to be used against you in a legal proceeding, specifically a criminal proceeding. So let's say, for instance, that the police get you to confess to a crime but then never charge you for it. Can you sue them saying you violated my constitutional rights because you questioned me without reading me my Miranda rights? And the answer that we get from Chavez versus Martinez is no, no, because the evidence has to be used against you in a legal proceeding. So, can police question you without reading you Miranda? Absolutely. Absolutely, they can, as long as they're not using it against you in a criminal proceeding. Now, could they use it at other instances? Potentially, right? We'll talk about collateral proceedings and things along those lines. But generally speaking, during the formal criminal proceeding, as long as it's not used against you, it is not a violation. And then finally, you are required or otherwise compelled to answer questions, right? Um, when we're talking about this, the idea is it can't just be a voluntary thing, right? You are being required to answer these questions. So the idea is you can't just kind of come forward out of nowhere without them asking you questions and be like, oh, yeah, I killed this person. And you're like, what? Oh, you didn't read Miranda. Well, nobody knew that you were going to talk, right? That you were going to confess. Now, that being said, keep in mind that when we talk about these requirements, there are some requirements to be mindful of. One of them is a BAC test, which does have some Fifth Amendment implications. Um, so, for instance, we have Schimber versus California. In this case, the defendant was treated at a hospital for injuries following a car accident. The police officer, suspecting that the defendant was intoxicated, directed the doctor to take the blood sample without the defendant's consent and without a warrant. The blood test showed that he was intoxicated, and the results were used as evidence in his DUI trial. The defendant was convicted and appealed, arguing that it was a violation of not only his Fourth Amendment, but of his Fifth Amendment because it caused him to be a witness against himself. His blood was a witness against himself. Now, that being said, when the court heard this, they said, well, sorry, right? The privilege against self-incrimination only applies to testimonial evidence and not physical evidence like blood samples. And therefore, right, it could not be used because, again, it was not testimonial, right? It was not testimonial. And here, the person's not being required or compelled to answer questions. It wasn't testimonial, right? It was just physical evidence being drawn from blood, right? Therefore, it did not qualify for protection against self-incrimination. So to recap, right, it has to be testimonial evidence. There has to be substantial and real threat that the evidence may lead to charges. The evidence must be used against the person in the legal proceeding, and it is required or otherwise involving compelled questions. So, what then does this come from in terms of what are your actual rights? Well, assuming we're talking about compelled statements or compelled testimony, the case that probably most of us have heard of, it's a very infamous case, a very, very, very famous case, is Miranda versus Arizona in 1966. So, most of you, if you've ever seen any police show on TV, have heard some version of the Miranda warnings. The Miranda warnings derive from the case Miranda versus Arizona. Miranda warnings are you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided to you before any questioning. Do you understand these rights? Right? That's it. But where did we get that from? Well, we got it from this case. So prior to 1966, if you were arrested, you just had to kind of know your rights. Okay? There was no requirement that anybody read you anything or remind you of your rights. That was until SCOTUS, under the leadership of Chief Justice Earl Warren, in his kind of criminal justice reform era, revisited the issue. So Miranda, right, involves a very not good person. It's actually a case that involves a lot of people. But at the heart of it, the named defendant is Ernesto Miranda. He was arrested in Phoenix, Arizona on suspicion of kidnapping and rape. He was a very not good person. After being interrogated for 2 hours, Miranda confessed to the crimes. However, Miranda was never informed of his right to remain silent or his right to an attorney. And again, at the time, they didn't have to, so the police department didn't do anything wrong. He then obviously confessed, and his confession was used against him. Miranda later appealed, saying that, hey, you should have to tell me what my rights are so that I know, what to do, and so I can make an informed decision. Ultimately, goes to the Supreme Court, and the Supreme Court said, actually, yeah, we are going to require that suspects be informed of their rights before any custodial interrogations. Right? So the person has to be in custody, custodial, which we'll talk about in a little bit, interrogations. Now, they understood that interrogations are inherently coercive, right? That you are scared, you're being questioned by police, you're locked usually in a room, and you're suspected of a crime by yourself, and there's people with guns there who want to put you in jail, right? It's going to be very nerve-wracking. And so therefore, it's really easy for a suspect's right against self-incrimination to be overcome by the inherently coercive nature of interrogations. And because of this, because we want to minimize the coercive nature and ensure that a person's rights are not violated, right? Police are now required to inform a suspect of their rights before custodial interrogation, with a note that this is not applied to non-custodial interrogations, right? When we say custodial interrogation, we'll talk about what does it actually mean to be in custody, but you have to be in custody. If you are not in custody, if police just kind of knock on your door and say, hey, just stopping by, just want to see if you had any crimes you wanted to confess to. You're not arrested, you're not under anything suspicion or anything like that, but just want to see if you have any crimes you want to confess to. And you go, oh yeah, I did this and this and this and this, and then they arrest you. Well, sorry, they didn't have to read you Miranda, right? Because you were not in custody. Once you are in custody, only then do the Miranda warnings have to be read before questioning commences. Now, that being said, the Supreme Court was was kind of a broad approach to Miranda. So the Supreme Court has consistently held that the Miranda warnings are not some kind of magical recipe or some kind of magical statement that has to be read verbatim. Right? Instead, police don't have to read some kind of magical formula to someone as long as they communicate that a person has the right to remain silent, as long as they communicate in some way that if they say anything, it can be used against them, that the person has a right to an attorney before and during questioning, and that if they can't afford one, they'll be given one. As long as they say that, they can say that in any order, they can use, differing language. But the idea is as long as they're communicating those points, even if it's not in the traditional format like we see on TV, it is sufficient, right? As long as it reasonably conveys an individual's rights as judged by a totality of the circumstances. Now, that being said, how far do these go? So one of the cases, and unfortunately it was not in your book to read, is Miranda versus Burbank. So in this case, what happens is a man is arrested, Brian Burbank is arrested in Rhode Island for burglary, and later becomes a suspect in a murder case. Now, while he's in police custody, he has read his Miranda rights, and he decides to waive them, subsequently confessing to the murder. However, unbeknownst to him, while he's in the interrogation room, his sister has gone out and gotten him legal representation from the public defender's office. And the public defender's office is trying to get a hold of him, trying to contact him, but the police never inform the suspect that he has an attorney, never inform the suspect that the police that he's trying to get a hold of him. And so the question here was, okay, does this negate Miranda, right? Because hey, he didn't have all the information he should have had. And the Supreme Court ultimately says No, this is not a violation of his Fifth Amendment rights because the police here had read his rights, right? Verbatim, the right to remain silent. Anything say can be used against you in court of law. The right to an attorney before, during questioning. If you cannot afford an attorney, one will be appointed to you. It doesn't say that you have to go further and tell him that he has an attorney trying to contact him or anything along those lines. The Supreme Court said sorry, right? You had the information. It doesn't matter if you knew an attorney was trying to contact you or not. You read your rights, right? You chose to waive them. It is what it is. So again, the police do not have to go beyond the scope of Miranda. They don't have to provide you more information, but they do have to provide you the baseline of the Miranda rights. Now, that being said, when we look at other countries, we're actually one of the first countries to introduce this concept, but other countries have surpassed us in how far those warnings go. For instance, Canada and Norway, there are countries that if you are arrested, right, not only are you read the equivalent of their Miranda rights, but they will have an attorney on speed dial. So police are putting you in handcuffs and they're holding up a cell phone to your ear in which you can talk to a criminal defense attorney immediately and get their advice on whether you should talk to the police and what you should do, etc. Right? Like that's a part of your rights being arrested. You get to talk to somebody immediately on the phone so you can make informed decisions. We've never gone that far, and it's doubtful, given the current political climate, that we will anytime soon. But understand that there's always room to grow. So that being said, we understand what Miranda is, and we understand that Miranda only applies to custodial interrogations. So that leads us to the question is, what is custody? So, as we said, officers are only required to read Miranda during a custodial interrogation. So in order to determine when somebody is in custody, we look at the totality of the circumstances and we ask, would a reasonable person have felt free to leave? If the answer is yes, a reasonable person would have felt free to leave, they are not in custody. If the answer is no, a reasonable person would have not felt free to leave, then they are, right, in custody. So custody doesn't always mean handcuffs or jails or police cars, right? We look at a number of the factors and we say, would a person feel like a normal person, would a reasonable person feel that they were free to leave, without catching a charge or something along those lines? So what factors do we look at? Well, we look at the number of police officers, right? The more police officers there are, the more likely it is you're probably in custody, right? If you're one person and you're surrounded by 20 officers, you probably aren't going to feel free to leave, right? But if it's a one-to-one, well, you might feel a little bit more free to leave depending on the other factors, right? Another question we ask is whether officers tell an individual that he or she is free to leave, right? Do they say that you are free to go? If they do, then you're free to go, right? If they tell you you're free to leave and you choose not to, that's not their fault. That's yours. You aren't in custody. Now, on this note, that's one recommendation that I have for all of my students. Is if you're ever talking to the police, ask the question, am I free to go? If they say yes, turn around and walk away, right? If they say no, understand that you're in custody and that Miranda does apply. We also look at the length and intensity of the interrogation, right? So something could start out as voluntary. You're not in custody. But if they keep asking you questions and you come in voluntarily to the police station, so you're free to leave at any time. You come in voluntarily, but then they ask you questions for 10 hours, and there's peppering you with questions and questions and questions and questions and questions for like 10 hours. At some point, right, that doesn't feel voluntary anymore. Now it's feeling closer to custody. We're asking as a stop in public or in private. And if you're by yourself in a lone street, you probably don't feel as free to leave as you would in a public venue. Other question to ask is whether the individual is restrained or if the officers use force. Remember, force is a continuum. It doesn't just mean handcuffs or a gun. It could be a shout, a stop, a raising of the voice. That's a form of force. Putting your hand on a gun without you pulling out of the holster, the form of force. So we look to see what do the officers do. The more force or any force that's used, the less likely it is you will feel free to leave. Let's talk about the familiarity with your surroundings. Are you in a new place for the first time? If so, you probably don't feel as comfortable walking away as you would do in a place you're at every single day. Now, this all kind of comes into will a reasonable person feel free to leave? There's no bright line requirements here. There is no, this is custody, this isn't. Instead, it's situational. Every situation is different, and we judge it by the totality of the circumstances. With that being said, I would like to note that there is a special consideration for minors, right? When is a minor in custody? Instead of looking at it from a reasonable person feeling free to leave, we ask, would a reasonable child of that age feel free to leave? So we look at these factors, but then we say, okay, will we view them from the perspective of a child who is this age? For example, unfortunately, you did not have this case. It's a very famous case called J.D.B versus North Carolina. In J.D.B versus North Carolina, a 13-year-old middle school student was suspected of involvement in some home break-ins in the area. He was pulled out of class and questioned by police officers and school officials in a closed-door conference room in the school. He was not given Miranda warnings, not told he could leave, and not provided an attorney or a guardian. During the interrogation, J.D.B confessed to the crime. Later, he sought to suppress his statements, arguing that he was in custody for Miranda purposes and he should have been given his Miranda rights. So the question becomes should a suspect's age be considered when determining whether they are in custody or entitled to Miranda? And the answer was yes. The Supreme Court ruled that J.D.B, right, suspect age has to be considered in the custody analysis. Specifically, right, looking at whether this child would feel free to leave. Because again, juveniles lack experience with the criminal justice system. They lack the maturity where they can make good decisions like an adult of, do I feel free to leave? Do I not? They tend to be more receptive to authority. I mean, think about as a kid, all the people you had to answer to versus being an adult. Right? And so understanding that we have to have special considerations for juveniles. Right? That we have to approach it looking from their age. Again, it's still the totality of the circumstances, but instead of just saying, how would a reasonable person feel, say, how would a reasonable 13-year-old feel, or a 7-year-old, or however the oldest person is, would they feel free to leave? Right? Would they feel free to leave? One last thing I want to discuss is custody during traffic stops, right? Generally speaking, during traffic stops, probation meetings, or search warrants, you are not usually deemed in custody, or you are deemed in custody, but Miranda does not have to be read. For example, when we think about traffic stops, when you get pulled over by police for blowing a stop sign, you are not free to leave. You are in custody. And Miranda does apply because you are in custody. However, because the stop is really brief, we do not require police to read you your rights. It's a weird caveat. So I'll say this again. Miranda rights do apply. If you are stopped by the police for blowing a stop sign, you do have the right to remain silent. You do have the right to an attorney before you answer questions, but police don't have to tell you. Again, why is this? Because stops are so short, it seems like it would be a waste of time. One of the examples that we have, right, and one of the cases on point, is Berkmer versus McCarty. So in this case, an Ohio Highway Patrol officer stopped McCarty after observing his car weaving on the road. During the traffic stop, the officer asked McCarty if he had been using intoxicants, to which McCarty admitted that he consumed 2 beers and marijuana. The officer arrested him and took him to jail, where he was further questioned without being read his Miranda rights. McCarty moved to suppress his statements, arguing that he should be given Miranda warnings before the roadside questioning. So the question then comes to this idea is, does the Fifth Amendment require police officers to provide Miranda warnings during routine traffic stops? And the answer was no. The reason it was no is the court ruled that traffic stops they're brief and they're public. Therefore, they are not as coercive as an arrest, and they are not required during the initial stop. This does not mean that Miranda does not apply. Miranda absolutely does apply. It applies to all offenses, including misdemeanors, once a suspect is in custody. Right? But traffic stops only become custodial when the suspect is formally arrested, but here they don't have to read it to you. So you can choose not to discuss. You can choose not to answer a question. If you think about it, there's a reason. There is a reason that police ask you the question, do you know how fast you were going? Right? Think about it, when a police officer comes up to your window, Some states have now changed this rule, but most states, they come up to your window and they knock and say, "Do you know why I pulled you over?" The reason they ask that is so that you make a confession. It makes the ticket harder to fight. Or they ask, "Do you know how fast you were going?" And most people, I love it. It's it's a 55, and they're like, "Oh, yeah, I was going like 57," thinking that that matters. It's like, no, that's you just admitted to speeding. It doesn't matter if you're 1 mile out over, they can give you a ticket. Um, so yeah, there's a reason for it. It makes stops much harder to face. So that's our custody, right? So in order for Miranda to be read, you have to be in custody. The next question is interrogation, right? So remember, it requires custodial interrogation. We understand what custody is. Now the question is, what is interrogation? So interrogation is usually defined as express questioning, right? So the person is asking you questions, or, and here's the big or, it's functional equivalent. Now, what is a functional equivalent? Well, it's really hard to identify. The reason it's hard to identify is because it really means words or actions on the part of the police, other than those normally attendant to arrest or custody, that the police should know are reasonably likely to elicit an incriminating response. Right? So the idea is you can be questioned in interrogation, or the police officers can use words or do things or make statements that are designed to elicit an incriminating response. Even though they're not asking you questions, they're doing something designed to eliminate a incriminating response that can be deemed as functional equivalent of interrogation. And if you're in custody, Miranda applies. So let's take an example. We'll look at two really famous cases on point. Rhode Island versus Ennis and Brewer versus Williams. Now, Rhode Island versus Ennis, this is our missing gun case. So what happens is Thomas Ennis was arrested for the armed robbery of a taxi driver and identified by the victim. After being read his Miranda rights, he requested a lawyer and was placed in a police vehicle for transport. While transporting Ennis, two officers discussed among themselves that the missing gun that he was believed to be used in the robbery could be found by a child, and the child could pick it up and hurt themselves. Hearing this conversation between the two officers, remember they're in the front seat talking to themselves, he's in the back seat. He overhears the conversation and he interrupts them, right, and voluntarily says, "I'll tell you where the gun is." Now, at trial, Ennis says that his statements about the location of the gun should be suppressed because they were obtained in violation of Miranda. So the question here was, does interrogation include conversations between officer that a suspect overhears and responds to? And in this case, the Supreme Court said no. That the conversation between the two officers was not an interrogation because it was not directed towards Ennis in a way that was meant to elicit a response. Instead, the two officers just driving on the way back to the police station were having a conversation among themselves about, how they hope that the gun doesn't get found by a kid, how bad that would be, right? Again, the conversation was directed towards each other. It was not directed towards Ennis, right? And it wasn't designed to get Ennis to confess to anything. So in this case, right, yes, he was in custody, but no, it was not an interrogation. Therefore, Miranda did not have to be read, right? Therefore, the statements stayed in place. But compare that to the other famous case, which is Brewer versus Williams. Now, in the later class, we'll talk about Nix versus Williams, which is the second part of this case. But this is the infamous case called the Christian burial speech case. So in Brewer versus Williams, Williams was a mental health patient and an escaped convict. He was suspected of abducting and killing a 10-year-old girl in Iowa. He turned himself in to police in Davenport, Iowa, where his attorneys advised him not to speak to officers without a lawyer present. While being transported back to Des Moines, officers engaged Williams in a conversation about how the missing girl deserved a, quote, Christian burial so her parents could properly lay her to rest. This elicited guilt in Williams, who eventually led police to the girl's body. At trial, Williams argued that his statements should be suppressed because they were obtained in violation of his rights to counsel, specifically that Miranda was not read. So the question here is, did the Christian burial speech, right, them talking directly to Williams, about it would be, we want this girl to have a Christian burial, it'd be great to know where she's at. The speech that it was given was that functional equivalent to interrogation. And here the Supreme Court said yes. Right? Yes, because again, the officers were trying to deliberately elicit incriminating statements after he had already invoked his, wanting to have an attorney. Even though they did not ask him direct questioning, their statements were designed to elicit a response that was the equivalent of Miranda, right? Or excuse me, an equivalent of interrogation under Miranda. So here, the big difference is Ennis, the two officers were just talking to each other. He overheard it. Here in Brewer versus Williams, the officers are giving him a speech and asking him questions, but they're talking directly to him in a way that would elicit him responding, right? Making incriminating statements, right? And so in this case, right, it is slightly different because they weren't questioning in either cases. There was no questioning, but the question is was it a functional equivalent? And this wasn't because the two officers were just having a conversation among themselves that this guy overheard. Whereas Brewer versus Williams, they were talking directly to the person, giving him a long statement. Right? Again, no questions, but the functional equivalent is they are doing something or using words that was reasonably likely to elicit an incriminating response. Right? And so therefore the case the at least this case the statement was suppressed, but then later in Nix versus Williams is a question about what's called inevitable discovery, which we talk about in a later class. Now, that being said, one thing to note, kind of on this point, is the Sixth Amendment right to counsel attaches an initial appearance for a judicial officer or when requested by a suspect. Police can no longer deliberately elicit an incriminating statement without a waiver, right? And so here in the Williams case, he had already talked to an attorney. Miranda was read. He talked to an attorney. He said, "Don't talk." And once he says he wants to invoke, he can't be asked questions unless he chooses or have some kind of deliberate elicitation unless he chooses to waive. And in this case, there was no waiver, right? Um, so once you will invoke, we'll talk about like how long you have to wait. But here he invoked the right to counsel, right? And then that cannot be overcome until you get the attorney. Now, along these lines about invocation and waiver. So generally, invocation or Miranda rights must be unambiguous. Right? Police are not mind readers. So if you want to invoke your right to remain silent or your right to an attorney, it must be done so unambiguously. It has to be done so with very clear precision. For example, one of the cases you read was Burgers versus Thompson. Now, in this case, Thompson was arrested in Michigan for a murder, and he was read his Miranda rights before being interrogated. However, during the 3-hour police interrogation, Thompson remained mostly silent, except for a few one-word responses here and there. Near the end of the questioning, police asked him whether he prayed for forgiveness for the shooting, to which he responded yes. This was later used as evidence in his trial. Thompson later argued that he had invoked his right to remain silent by not speaking for most of the interrogation, and that his statements should be suppressed. So the question here was, did Tompkins invoke his right to remain silent by just being silent? And here the Supreme Court said, no, he did not invoke his right to remain silent by just being silent, right? That it requires, an invocation of rights requires an explicit statement that you choose to remain silent. Because again, police are not mind readers, right? They can keep that interrogation going, even if the person's not answering their questions, up until the point that they choose to remain silent, right? And they have to say it. Similarly, when we look at other cases, again, that you necessarily haven't read, including Fair versus Michael C., which we'll talk about in a little bit, Hart versus AG, and Davis versus United States, this also applies to right to counsel, right? You have to be very, very, very explicit, right? You have to be very explicit of what you are invoking. So, for instance, as we learn in these cases, you have to say, I want an attorney. Not, I think I want an attorney, or do you think I should get an attorney, or do I need an attorney? None of that is an invocation. You have to explicitly say, I would like an attorney. Right? Similarly, like, should I remain silent? I don't think I should talk to you. I don't want to talk to you. Sorry, no, that's not good. I choose to remain silent. Right? You have to explicitly say it. If you do not explicitly say it, since police are, quote, not mind readers, they can continue questioning you, even if you said, no, I think I might want an attorney. Now, police could keep questioning you. The best practice is for police to say, okay, just to be clear, are you saying you want one or not? Right? To make sure they remove any uncertainty. But again, they're not mind readers. You have to say it with certainty, right, to invoke. Similarly, right, to waive, under certain circumstances, you have to show that once you've invoked your right to remain silent, if you choose to then waive it, right, or even if you haven't invoked, you choose to waive Miranda, you must do so voluntarily, knowingly, and intelligently. So we say that, when you decide to waive Miranda and talk to police, did you do so voluntarily? Right? Did you do so of your own accord? You weren't pressured. Did you do so knowingly, knowing what the consequences were? And did you do so intelligently? Right? Did you have enough information to make this decision? And were you of generally the mindset to be able to do this? So, what do we look at to see whether somebody was capable, right, of waiving Miranda? Well, we look at a number of factors to make sure it's voluntarily, knowingly, and intelligently. One of the factors we look at to make sure that the person has legally waived the Miranda rights is the suspect's demographics. Right? We look at them and to see, like, do they have mental impairments? Or what's their IQ? Like, how intelligent are they? That being said, age can come into play, but it is not determinative. For example, a case that you didn't read, I mentioned above, is Fair versus Michael C. Again, this involves a juvenile case, right? In this case, Fair versus Michael C. Michael C. is a juvenile. He's taken into custody as a suspect in a murder investigation. Now, before the police interrogation, he was Miranda, and instead of requesting an attorney, he asked to speak to his probation officer. The police denied the request, right? Said no. After which, Michael agreed to talk to the police, and he made incriminating statements, which was later used against him, and he was convicted. Now, the problem here is he's later said that I requested my probation officer that's basically like an attorney. I'm just a kid, so I didn't really know the difference. And the Supreme Court said tough, right? That your age alone, right, does not constitute a waiver or even an invocation of Miranda, right? That just because you're a child doesn't mean you can't waive Miranda. You absolutely can, right? So kids, minors, can be read Miranda rights and can voluntarily and knowingly waive them. Now, along these lines, I want to say is yes, juveniles can waive Miranda. So you can have a 13-year-old who can say, "I know my rights, and I choose to waive them." But, right, because they are minors, it does require that during an interrogation there be what's called an interested adult present. Now, this does not mean a family member, and this does not mean a lawyer. This can be any interested adult. Anybody who would be interested in this juvenile's welfare has to at least be present, right? Um, so this could be that next door neighbor. It could be just somebody who, in theory, could help you. It doesn't have to be your parents. It doesn't have to be a lawyer. It just has to be somebody who could help guide you. That's the only special requirements. Because beyond that, minors can easily waive Miranda and decide to talk, right? It doesn't have to be signed off by parents. It doesn't have to be signed off by guardians. Minors can choose to do it as long as, again, there's some kind of interested adult present. Other things that we look at to see if the waiver of Miranda has been made voluntarily is conditions of interrogation, right? How long have you been in this room? What does the room look like? Is it bright? Is it sunny? Is there a window? Is it this broom closet and you've been in a broom closet that's really hot for, 12, 14 hours being questioned? Well, one of those seems a lot more voluntary than the other. Let's look at interrogative techniques. Were you threatened? If you were threatened, sorry, that's not voluntary. Were you pressured too much? Were you screamed at? Right? We'll look at all of this to see if you choosing to talk to me, is it a valid confession? We also look at your motivation. Why did you talk to police? Right? Were you doing it for just hoping to get a reduced sentence, or were you doing it because you legitimately thought you'd get off? Why did you talk to police? So again, we look at all this once Miranda's been read, or you decide to invoke and then uninvoke, or however you decide to waive Miranda. We have to ensure that it's done voluntarily, knowingly, intelligently, looking at the totality of circumstances, specifically of the individual and the interrogation. Along these lines, when we talk about reading Miranda, we prefer express waivers over implied waivers, right? Um, the express waiver is basically saying, yes, I'm choosing to waive my Miranda rights, and yes, I will talk to you. However, I mean, that's our preference. However, in some situations, what's called implied waivers will satisfy the Fifth Amendment. So you have the right to remain silent. Do you understand your rights? Do you want to talk to us? And then instead of just saying yes or I'm waiving my rights, you just start talking and blabbing after they've read you your rights. That could be easily considered an implied waiver. So, for instance, again, a case that you did not get to read was North Carolina versus Butler. And in this case, Butler was arrested in North Carolina for kidnapping, armed robbery, and assault. Before interrogation, police read him his Miranda rights, and Butler stated that he understood them. However, he did not explicitly say that he wanted to waive his rights. Instead, he later voluntarily answered questions and made incriminating statements. At trial, he moved to suppress the statements since they were never explicitly waived after he was read his Miranda rights. So the question here is can you implicitly waive your Miranda rights by answering questions after you've been read your rights and not saying I choose to waive it? The answer is yes, right? We prefer that you explicitly say I'm choosing to waive my rights to talk to you. But if you just start talking after you've been read Miranda, all right, you waived it, right? You waived it. A waiver can be done by a suspect's words or their actions, even if they do not explicitly state, I waive my rights. Right? Now, that being said, that does raise some questions, right? One of the questions happens, and again, it's an Oregon versus Estad, which I think your book references, but it doesn't go into a lot of detail about, is what about waivers that occur um, after the fact, right? So what I'm talking about here is a process or technique called question first and read later. So sometimes police officers will make an arrest and ask questions before reading you Miranda, right? They're asking you questions, getting you to confess to some stuff. Then later on, they take you back to the station, they read you Miranda, and they ask those same questions. Now, anything that they've asked, right, when you're in custody, if they haven't read Miranda, it's not admissible. So they know perfectly well that stuff that they've just asked you is not coming into evidence. But let's say they realize they messed up, so they take you down to the station, they read you Miranda, and then they ask you those same questions again. Is that admissible then? So this was a case on point called Oregon versus Estad. In this case, police officers went to the home of Michael Estad, a 18-year-old suspect in a burglary case, to arrest him. While at his home, before giving Miranda warnings, one officer casually said he suspected Estad was involved in the burglary. Estad admitted his involvement. Later at the police station, after giving proper Miranda warnings, Estad waived his rights and gave a full written confession. In trial, Estad moved to suppress both statements, arguing that his initial unwarranted statement tainted his later confession and made it inadmissible. So the question for the Supreme Court was, does the suspect's unwarned but voluntary statements automatically make later warned confessions inadmissible? And the answer here was no. The statements that he made before he was read his Miranda warnings are inadmissible. But after he was read Miranda, right? Yes, there's a violation, but it's not necessarily coercive. He was given some time. He was read Miranda, and he was asked questions, right? The properly warning, the proper warnings reset the situation. So once you've read Miranda, now you know what your rights are, and you can and if you waive them, the confession is valid, right? So again, even if police mess up it's in their best interest to then stop, read Miranda, and then question again. If you choose to waive after they've read Miranda, even though you've already talked to unmirandized, those second set of statements can come in if you have been read Miranda and you choose to waive it, right? Um, that being said, SCOTUS is now requiring that if officers mess up, they have to tell you. They have to, hopefully, um, that the first statements you made are inadmissible, right? And that you now have the right to keep talking to police. So that's a fairly recent requirement that if police mess up, they forget to Mirandize you, they're going to now Mirandize you, question you, to say, hey, by the way, when you first talked to us, those statements are not admissible in a court. Do you want to go ahead and talk to us now that you've been read Miranda? Right. So we are trying to make it a little bit more clear. It's a fairly recent development in Supreme Court case law. Now, that being said, one thing to note is we're talking about invoking Miranda or waiving it. Waiving Miranda can occur at any time, right? So you can choose to waive Miranda rights whenever. You can choose to waive Miranda rights immediately. You can choose to waive Miranda rights after 6 months. It's entirely up to the person being questioned, right? That being said, right, when we're talking about an invocation, right, invocations can also be invoked at any time. So let's say, for example, you decide to waive your Miranda rights. You say, I'm going to talk to you. So you're talking to the police. And about halfway through, you go, ooh, crap, I shouldn't be doing this. I don't want to say anything else. I want to now remain silent. You can do that, right? You can talk for a little bit and then invoke. Anything you said before you invoked is admissible, but once you invoke, right, then you have to, as the questioning has to be scrupulously honored, right? If you say I want to remain silent, they have to stop. If you say I want an attorney, they have to stop, right? When you invoke in Miranda after you've already waived it, the questioning has to stop immediately, and just speaking has to be suspended for a significant period of time. Right. So if you say I want to remain silent, generally speaking, the questioning has to stop immediately. And then after about 24 hours, the police can come back. They can read you Miranda again and then say, do you want to talk to us or do you want to waive? Or do you want to talk to us or do you want to remain silent? You can say, I want to remain silent. Right. And they can, wait again and again and again. So if you choose to remain silent, you get about a 24-hour period before they can come back. Read you Miranda and start asking you questions. If, however, you say, I want an attorney, right? If you want an attorney, then that has to be scrupulously honored until you get to talk to an attorney. They can't come back after 24 hours, unless you have an attorney present. So it's always best to read the attorney one or to invoke the attorney, but either of them will do in a pinch. Remember, even if you've already started to talk to police, you can still re-invoke them. You can't be like, well, I've already said a couple of things. Do damage control. Stop, stop immediately, ask for an attorney. Anything you've already said can come into evidence, absolutely. But it's when you find yourself in a hole, the very first thing you do is stop digging. Right? Stop digging. So, that being said, that's our waiving. Are there exceptions to Miranda? Are there times when Miranda should be read but doesn't have to be? You know the answer. The answer is yes. Right? Specifically, one of the biggest exceptions that's recognized is called the public safety exception. So the public safety exception permits police to ask questions before reading Miranda rights to a suspect if reasonably prompted by a concern for public safety. Right? So the idea is they're asking you something in the moment, like I don't have time to read Miranda. There is danger present. Right? Now the problem is anything you say can be used against the suspect. So even if they didn't read Miranda, if there was danger present and public safety was at risk, right? The idea is anything they say can be used, even though Miranda was not read. So to trigger this exception, generally speaking, three factors have to be present. So in order for the public safety exception to Miranda for it to apply, one, the police must have a reasonable belief that a threat is immediate, right? This is not a threat that could happen 3 years down the road or next month. The idea is like it's an emergency. I need to know right now. I can't afford you being reminded you don't have to talk to me. And again, even here, if police suspect an emergency, do you have to talk to them? No, you don't have to. The thing is, we're not going to require them to remind you you don't have to, right? So, reasonable belief that a threat is immediate. Second, the questioning must be directed towards protecting public safety rather than establishing guilt or innocence. So, if there's a bomb that's about to go off. They can't ask you, so did you build this bomb? No, the question is, where is the bomb? Right? Um, Again, they're not trying to establish guilt or innocence. They're just trying to protect public safety. And the statements must not be the product of police compulsion that overcomes their suspect's free will to resist. Emergency tensions run high. Can a police officer throw you against a wall, like put his hand on your neck and be like, "Where's the bomb?" And you go, "Oh, it's up there." No, because at that point, you've overcome your free will. Just because it's an emergency, all we're saying is police don't have to remind you of your Miranda rights. But your Miranda rights still do apply. You still don't have to tell them jack. You don't have to tell them where the bomb is. You don't have to tell them what the code is. Like, you can remain silent, you can ask for an attorney, and it has to be honored. We're just talking about they don't have to remind you. They don't have to read you Miranda rights. So again, reasonable belief that threat is immediate. The questioning is only towards protecting public safety, and that there's no police compulsion. There's no threats of violence or anything physical like that. With that understanding, public safety is a fairly vague term. One of the most famous cases on point, which you all did read, is New York versus Quarles. New York versus Quarles, a woman reported to police that she had been raped at gunpoint in New York City supermarket, and she described her attacker as carrying a firearm. Officers quickly located the suspect of the rape, Benjamin Quarles, inside the store. After a brief chase, officers apprehended Quarles and noticed that he was wearing an empty shoulder holster where the gun had been. Before giving Miranda warnings, the officers asked, "Where is the gun?" Quarles nodded towards some boxes and said, "The gun is over there." Quarles was then read Miranda rights, formally arrested, and charged with criminal possession of a weapon. At trial, Quarles moved to suppress his statement in the gun, arguing the officers failed to read him Miranda rights before questioning him. So the question was, does the need to protect public safety allow police to question the suspect without first reading Miranda warnings? And here the answer was yes. The Supreme Court ruled in favor of New York, holding there was a public safety exception to Miranda, allowing police to ask limited questions without warning if necessary to protect the public from immediate danger. All right, so again, here we have a gun in the middle of a supermarket that can be picked up by anybody and hurt somebody, or the suspect could lunge for it and grab and hurt officers with. So because of that, we say that that's public safety. They can ask that question. A case that's kind of similar is one that you didn't read, which is United States versus Reyes. In United States versus Reyes, Raymond Reyes was arrested in New York City during a buy-bust operation targeting his heroin distribution activities. Confidential informant had informed the NYPD that Reyes regularly sold narcotics and carried a firearm during his transactions. The confidential informant arranged to purchase 200 envelopes of heroin from Reyes at a Bronx bodega near a school. Upon Reyes' arrival, the confidential informant entered his car and confirmed the presence of narcotics, but did not ascertain if Reyes was armed. Officers then moved in to arrest Reyes. Before cuffing or issuing Miranda warnings, an officer asked Reyes if he had anything on him that could hurt the officer or the field team. Reyes admitted to having the gun in his pocket, which the officer retrieved before cuffing him. The officer then inquired if Reyes had anything else that could cause harm, to which Reyes responded about the drugs in his car. Subsequently, officers found nearly 200 envelopes of heroin in the vehicle. So the question is, did the public safety exception to Miranda permit the admissibility of statements and evidence obtained without prior Miranda warnings when officers inquired about potential dangers during an arrest? And here the Second Circuit said yes. When an officer asks you before reading Miranda, do you have anything on your pockets or on your person that might hurt me? Even if they haven't read you Miranda, that's public safety. Because they're not asking to prove guilt or innocence. They're asking to ensure that if they go into their pockets, they're not going to be stabbed or poked or a gun's going to go off. They're trying to ensure safety. Now remember, anything you say, even though they're trying to ensure safety, can be used against you, but it's an exception for a reason. Now, one case I was involved in particular involves the Boston Marathon bomber. When he was arrested, even though he was taken to the hospital with like 40 some gunshot wounds, he was interrogated without Miranda being read. because again, he had just planted bombs in different places and threw bombs at police. So the question is, are there any more bombs out here that we need to know about? At this point, they're not trying to establish guilt or innocence. Instead, they were trying to ensure that the public was safe. With that being said, right? With that being said, even if Miranda is read and Miranda is proper and a suspect confesses, right? This does not mean this does not mean that the confession will necessarily be admissible. Instead, we understand the Fifth and Sixth Amendment protections. We understand that the 14th Amendment also applies. Specifically, right, the 14th Amendment says that nor shall any state deprive any person of life, liberty, or property without due process of law. So the idea is we have the due process clause. We understand that confessions, even if Miranda have been read, can violate the due process clause, right? If they are obtained through even Miranda's read and they threaten you or they torture you, right? That is a violation of the Constitution. So just because Miranda's read doesn't mean a confession is automatically admissible. Instead, it's only admissible if it does not violate the 14th Amendment. So let's talk a little bit about admissibility, right? A confession violates the due process clause if, one, the suspect is subject to physical or psychological coercion, and two, the coercion overcomes the will of the individual to resist. Now, along these lines, when I say the suspect is subject to physical or psychological coercion, understand that at this point, any physical coercion, any physical like torture or anything like that will automatically make it inadmissible. I don't care if it overcame your free will or not, right? If it's physical, you're done. Where things come into play realistically for us in this modern day and age is this idea of psychological coercion. Right? If a suspect is psychologically coerced, that's generally fine. We talk about my criminal investigation class interrogation techniques, and there is like a lot of psychological coercion that takes place. And some psychological coercion is okay as long as it does not, number two, overcome the will of the individual to resist. Right. So you can apply pressure and try to trap the person and try to get a confession. You can use some psychological manipulation, right? As long as that coercion or that manipulation does not overcome the individual's free will to resist. So, how do we determine if a confession violates the 14th Amendment? We look and see, based on the totality of the circumstances, right, what happened. Okay? So again, totality of the circumstances. Was there physical abuse? If there is, you're automatically done. Was there psychological abuse and manipulation? Okay, if there was enough to overcome the free will. What are the demographics of the suspect? Right? Obviously, it's going to be much easier to overcome the free will of a child as opposed to a grown adult. It's going to be, it comes into play. For instance, one of the things that we have under this is Colorado versus Connolly. Right? This is a case that you all read for this class. In Colorado versus Connolly, Connolly was approached by a Denver police officer and voluntarily confessed to a murder he had committed years earlier. The officer read him Miranda rights, but Connolly continued to insist that he wanted to talk. Later, Connolly's mental illness became evident, and he was diagnosed with schizophrenia. He later argued that his confession was not voluntary because his mental illness impaired his ability to make rational decisions to waive his rights. He expressed a confession claiming that it was a violation of his Fifth and 14th Amendment rights. So the question is, can a confession be deemed involuntary under the due process clause if there was no police coercion, but the suspect was mentally ill? Now here, the Supreme Court said in this case, generally speaking, no. Right? No. Because again, what is the Constitution designed to protect? The Constitution is designed to protect you from police or state, right? Coercion. In this case, the officers didn't do anything. Right? The officers did not do anything. Instead, it was this person's mental health that did it. The state did nothing wrong, and so the state, right? There's no deterrent effect by getting rid of the confession, because the state did nothing wrong, right? Now, if it'd be a little bit different, maybe if the officer had known This person has a mental illness, and then used his mental illness against him to try to elicit a confession. At that point, that would maybe change this under the totality of the circumstances, right? He was schizophrenic, and so the guy was trying to like trigger his schizophrenia and and question him in some kind of way. That would be different. But in Connolly, the officers didn't do anything wrong. They didn't do anything at all. He just came up and straight up confessed, right? Um, so that's why Connolly, it was a no-go. But again, if police officers had done stuff to trigger it or tried to manipulate his mental illness, that would be probably a little different. We also look at procedural irregularities, right? Did they not read Miranda? Did they read Miranda, but it took them 3 times to get it right, or they questioned him for 3 days and forgot to read Miranda, and they finally did, and this person confessed? That could come into play. Also look at the necessity of the confession. If police have all the evidence in the world, they have DNA, they have eyewitnesses, they have video camera footage of this person doing it, they don't need a confession. More likely than not, that confession's voluntary because there's no reason to torture the guy. You have all the evidence to get a conviction, but the whole case hinges on the confession. There is no other evidence. Then it seems like coercion would be a lot more likely because you want the person to confess. You need it. You have to have it in order to make the arrest. And we look at other factors surrounding the interrogation, right? Again, how long had you talked to this guy? You interrogated this person for 20 hours, and was he given bathroom breaks? Was he given food? At some point, right, we're going to say that that's unbelievably unreasonable. If it was a short amount of time, the guy was given bathroom breaks and given food, and there was like windows in the room, okay, that's different. If he's down in a dungeon for 20 hours, he's only had one bathroom break and some crackers, that's going to be a big problem. But even though I just said this turns on the idea of state coercion, there can be one caveat, and that is coercion by private citizens. So one of the cases that we see here that you had to read was State versus Bowie, right? Or Bow, however you want to pronounce it. So in this case, basically what happens is there's a brawl that occurs on the campus of the University of Hawaii, specifically in a dormitory. During the brawl, the defendant, or excuse me, Stephen Osharawa, I can never say his name, was beaten, sustained injuries. Right. The defendant was a member of the university's um, basketball team and was implicated in the incident. After the incident occurred, after the attack occurred, the defendant's basketball coach urged him to cooperate with the police investigation. And then the coach facilitated a meeting between the defendant and the police, during which the defendant provided statements regarding the incident, basically admitting to the attack. So, he was obviously convicted at trial and he moved to suppress the evidence. The issue was, can the coercive conduct by a private individual, such as a coach, render a defendant's confession involuntary and thus unadmissible under Hawaii law? And the answer here was yes. And the reason the answer here was yes was a little bit different than Connolly. So, Constitution of Colorado provided that the reason that we don't want involuntary confessions is to provide against police misconduct, right? If Hawaii had the same provision, then it probably would have been admissible. But Hawaii's constitution went even further than Colorado's. Instead, Hawaii's constitution specifically talked about wanting to prevent or providing people a right against coercive confessions to ensure that people would have voluntary confessions that were respective of their free will. In other words, Hawaii's constitution provided broader protections than the U.S. Constitution or state or like Colorado's constitution. As such, under the reading of Hawaii's constitution, coercive conduct by an individual can render a confession involuntary. Compare that to the federal constitution or other state constitutions, like Colorado, where it does not. So, generally speaking, in most states, can you be coerced by a private person? The answer is no. However, if a state, like again, like that's Colorado versus Connolly example. However, if a state, right, has special protections in its own constitution, then yes, the state can say sometimes Hawaii being the example, that a private person can overcome the free will. But generally speaking, this is the exception to the rule. The general rule is private people can't, right? It is usually just talking about state misconduct and police officer misconduct. Whether, you're terrified of going home to mom and you're afraid the mom's going to scream at you, so you confess, is usually irrelevant, right? Usually we're only concerned about the state. That being said, right, other factors that we kind of consider when we're thinking about admissibility is, let's say that even if you know your your confession does not violate the 14th Amendment, there are other rules that can kind of, and constitutional protections that can come into play. For instance, one of the rules that we see adopted by the federal courts is called the McNabb-Mallory rule. And the idea here is, right, regardless of whether an individual's confession has, overcome their free will, we here, as a matter of federal law, say, okay, if a defendant has been detained for an unreasonably long time between their arrest and the preliminary hearing, any confessions obtained between the arrest and the hearing are not admissible. Even if we can say, hey, you know what? Hey, you know, he freely and voluntarily confessed. The problem is if we waited too long between the arrest and the time that the person goes in front of a judge, if you wait too long, then the confession gets automatically thrown out, right? If we actually look at the rule in the 1960s, was 6 hours, right? That was the rule. 1960s was the rule. So in the 1960s, if you were arrested and it took them 7 hours to get you before a judge and you confessed in between, that confession was automatically thrown out, which is not a great rule, right? Not a great rule. Because, like, God forbid you're arrested at night. So what happens is today we got rid of the Omnibus Crime Control Act rule, and instead we just use time as one of the factors for admissibility, right? So we look and say, those other factors we looked at, what was the techniques used, what was the person's demeanor, what was the room like. We also looked how long has it been between being arrested and did you see a judge, right? We look at kind of things along those lines. That being said, right, we also understand that um, this is obviously a very important thing because, again, not only do we have the Fifth Amendment, we also extend the Sixth Amendment right to counsel, especially during when it comes to confessions, because a competent lawyer would instruct clients never to speak. That being said, why are we so concerned with Miranda ensuring that confessions are not coerced and that they're admissible? Reason we're concerned is false confessions, right? That's the thing that we are trying to avoid more than anything else in the world. So a false confession, right, is different than an involuntary confession. Involuntary confessions are you did it, but somebody tortured you or pressured you or overcame your free will to resist. Those are inadmissible. As bad as those are, what is worse and can often be triggered by involuntary confessions are false confessions. Here, you didn't do it, but you admit to doing something you didn't do. So we're thinking of false confessions. There's actually three types. There are voluntary false confessions, compliant false confessions, and internalized false confessions. A voluntary false confession is knowingly given in response to little or no police pressure. So this idea is you walk into a police station and you confess to a crime that you did not do. And you think to yourself, why does this actually happen? Sure does. Why? Well, it happens a lot, especially in big cases that get nationwide attention. Right? Whenever you see a case followed on the news, like a missing person or somebody is murdered and nobody has any leads and they don't know who did it, false confessions go through the roof because some people just want to be famous and they think if they confess to a bad enough crime or one that's in the public attention, they'll get the fame that they want, even if they didn't do it. Right? There's little to anything that the police can do or our system can do besides investigate it and then say, no, you didn't do it. You're just, not super well mentally. Where things start to get a little bit more complicated is compliant false confessions. Right? This is when you knowingly give a confession to put an end to an interrogation or to receive a promised reward or benefit. Right? So here, you know you don't do it, but police have put such pressure on you that you just admit to it. If you think to yourself, man, I would never falsely confess, you're wrong. You would, right? We all would. There's virtually nobody strong enough if they get subjected to enough interrogation for long enough that they wouldn't confess. And we see this a lot, especially when police start to promise things. Man, if you just tell me you did it, I'll talk to the DA. I'm sure you'll just get probation. Right? They're like, oh, like I've been here for 20 hours. If I don't confess, I'm going to get the death penalty. God, well, I'll just confess, right? And that way I won't die. That happens. It happens. There's a compliant false confession. You confess to something you didn't do because the consequences of not confessing are so great that you just don't want to take the risk, but you know you didn't do it. Those are problematic, and we try to fight those as best we can um, with our protections, constitutional protections of making sure that confessions are voluntary and all that jazz. The last type is our internalized false confession. This is where you confess to something um, because you start to doubt your own memory or you start to accept the police version of the facts, right? You go into it thinking, I didn't do this. You know you didn't do this. But as you get questioned, presented with evidence, you start to think, oh, well, maybe I'm wrong. Maybe I did do this. Maybe I blacked out. I don't remember doing it. You didn't do it. You didn't actually do it. But police start to convince you, and you convince yourself that you did it. And you start to truly believe you did do this thing that you did not do. It's not common that this happens, but it does happen. And when it does happen, a person will fully believe that they did something that they did not do. They won't trust their own memory, they won't trust their recollection of facts, and they start to believe that, yes, they committed a crime that they didn't actually commit. Right? And so compliant false confessions can easily turn into internalized false confessions, depending on the nature of the interrogation, the susceptibility of this person, intelligence level of this person, age. We'll talk about factors that are present in false confessions. But these are the three that we have. Voluntary is usually just for notoriety. Compliant is the most common that we see, but things can end up becoming internalized. So, what then is likely to trigger a false confession? There's several things that can trigger it. The first being age, right? Um, Juveniles are much more likely to false confess than to like middle-aged people, but old people are also much more likely to false confess to the middle-aged people. The reason this happens is brain and brain development, right? Young brains are still forming, so they're susceptible to persuasion and pressure, whereas old brains, right, they're starting to deteriorate, so they become a little more susceptible to persuasion and pressure and coercion. Intelligence, right? Generally speaking, less intelligent people, we're not talking about, average intelligence, but less intelligent people, people maybe with intellectual disabilities, are much more likely to false confess than people of average intelligence or high intelligence, right? Um, Unfortunately, we do see this a lot, especially when people have, intellectual impairments, right? So if somebody has a really, really low IQ, associated with some kind of intellectual disability, they often false confess to things that they didn't do. You can trick them into believing it. We also look at police bias, right? When I say police bias is if police believe that you are the suspect and there is no other, even if you didn't do it, if they are certain you did it, your chances of false confessing skyrocket. Whereas if they have like three or four suspects, your chances of false confessing are minimal. But they're just focused on you and everything they try to spin everything you say, then yeah, it's more likely you'll falsely confess. Um, Misleading remarks, right? Please make misleading remarks to you. More likely you should falsely confess. Um, and this includes false evidence, right? So police can come and be like, I have your DNA at the crime scene. You need to confess to me right now. If you confess to me right now, I'll talk to the judge and they'll go easy on you. If you don't confess, I can't help you. Well, guess what? Police can lie. They might not have any DNA, it might not match you, whatever, but they're just trying to get a confession. Well, if they present you with like DNA or video footage that's been doctored of you, your chances of confessing skyrocket, even if you didn't actually do it. And that's completely legal, by the way, completely legal. The length of the interview, right? Lengthy interviews, the longer the interview, the more likely it is you're going to falsely confess, versus the shorter the interview, the least likely it is you're going to confess. And then the interrogation technique. The most common one used in the United States that is very abusive, in my personal opinion, but is always designed to elicit confession, right, is the read technique. If you take my criminal investigation class, we talk a lot more in detail about the read technique, but it really truly is targeted psychological pressure that hopefully doesn't overcome the free will, but it often does. With that being said, understand that yes, we have protection against self-incrimination. Miranda is one of the big bulwarks against self-incrimination, but there's exceptions to Miranda. And even if Miranda is followed to a T, and confessions can still be inadmissible, right? Especially if there is coercion or is confession that was obtained in violation of the 14th Amendment. And the reason we're so concerned about it is false confessions do happen. They are one of the number one causes of wrongful convictions in the country. That being said, I thank you for your time in watching this presentation. I hope you have a wonderful day.